Yet again, the Supreme Court has unsettled its own settled law in favor of sticky taping a person-specific sub-constitutional bill on top of the Constitution. Judges being brought in to disqualify lawmakers for being immoral was not a Zia-era fiat. They were included in Article 62(1)(f) for the first time by our own elected Democrats through the 18th Amendment. A lawmaker is, for that reason, ineligible for as long as there's a court declaration to the contrary, as held absolutely correctly by Justice Yahya Afridi in his dissent. So for the previous regime to have tried to get around that same amendment by distorting an ordinary law, the Election Act of 2017, that was plainly wrong. But this Supreme Court seems to be in the habit of legalizing the bad laws of minority governments each time they circumvent the will of the people, the dignity of Parliament, and the need for a constitutional amendment via a two-thirds majority. So between passing that bogus practice and procedure law and now appending electoral disqualification, whatever next government shows up and whatever its nature is, it should be confident in never having to need to affirm Parliament and marshal the numbers to amend the Constitution, given that this court is so willing to accommodate whichever fly-by-night ordinary legislation is passed to disrupt the existing constitutional scheme. So a decision that has read into Article 62(1)(f) for a rather specific purpose.